All right, welcome everyone. I'm Mark Sutcliffe, and it's my pleasure to welcome you to this webinar about getting back to work and some of the employment issues that arise from that. And I'm joined by JP Zubec of Kelly Santini. Hi, JP.
Hey, Mark.
So before we get started, of course, because you're a lawyer, JP, you have to start by giving a bit of a disclaimer, right, to make sure we know the rules here.
Yes, actually, there's a story behind this because I've spoken before and done webinars, and I've never read a disclaimer. And Keith, our marketing guy, who does a great job, he contacted me yesterday and he goes, "Well, you need to read a disclaimer. Here, read this disclaimer." And immediately I thought, oh, okay, I'll read the disclaimer. And then I thought, why am I taking legal advice from our marketing guy? It took me an hour to figure that out. And so anyway, on the advice of Keith, I will paraphrase the disclaimer. It's a presentation for educational purpose only. In these cases, the devil is in the details. So if you need legal advice, I recommend you retain a KS lawyer who can give you advice based on the specific circumstances that you're dealing with. So there you go. It's done, Keith. I hope you're happy.
And I hope Keith is willing to take marketing advice from you if that's the if that's the case. It's only fair, right?
Yeah, that's right.
Yeah. So to start with, I mean, I think we're open to questions here on any aspect of employment law as it arises from the coronavirus crisis, of course, but I think we're focusing the majority of our time on the going back to work scenario and what some of the issues are that arise out of that, as people reopening their businesses or workplaces, and people returning to work, people in some cases not wanting to return to work, maybe some companies who only want to bring certain employees back and not others. Responsibilities around protecting workers, those kinds of things. So to get started, maybe you can just provide an overview of what employers should be thinking about as they reopen their workplaces.
Sure, and that covers a lot, so we can unpack some of the various issues that we're going to just touch on, and then we can come back and visit them in more detail later. So the first thing that I would do if I was a business owner is I would strike a committee on reopening the business, and that committee is going to want to address a number of things. First of all, the province of Ontario has hired several more health and safety officers, so there's a good chance that a health and safety officer could be visiting your business, and I think you should proceed on that assumption. So you want to make sure that you're compliant with the existing obligations under the Occupational Health and Safety Act before you even get started. So things like, do you have a health and safety policy? Do you have a joint health and safety committee? Do you have a health and safety representative? Do you have a workplace violence policy or a harassment policy? So get those all in place. They're almost like the canary in the coal mine. When an HSO walks into the workplace, they're going to see these things are in place and they're going to think, okay, this employer is on his or her game. So the second thing you want to do is I would carefully review the guidelines that have been released by the province of Ontario. I believe, and I looked at the list, nearly all, if not all of the attendees have businesses that are regulated provincially. There is a small number of businesses regulated federally, banks, airlines, things like that, but most of us fall within provincial regulations. So follow those guidelines. I think they're well done. They have different guidelines for different types of industries, and they have recommendations and best practices for things like hand washing and use of different equipment. So I would print those off with the committee, go through and make sure everything is in place. So, and then now you're at the step where, okay, everything's in place, we're ready to recall employees. And this is a crucial step. You're going to want to, just one second, I'm receiving emails. Pardon me, I'm going to just make sure I don't receive any more emails. So what you're going to want to do is you're going to want to think carefully about who it is you're going to be calling back. And this is not really employment law advice, it's more management operational advice, but what do you need to exist in the first few weeks? Then you're going to prepare recall letters, and I should back up. On the process where you're deciding who you're going to recall, you're going to have to make sure that you're not making any decisions based on a ground that's prohibited by the Human Rights Code. So, and sometimes most clients you have are good people, but good people can still invariably violate the Human Rights Code because it's designed to apply to a broad circumstances. So sometimes you find people that have good intentions that still end up violating the code. So things like this person is on a disability, or you have an employee who's on a disability, he's not very productive. Well, maybe you want to slide him or her to the bottom of the list. An employee that just came off mat leave, things like that. So do your best to eliminate any of those considerations. Then you get to the stage where you're going to be recalling employees. And the next thing I would do is I would put that in writing, and I would get ahead of the message. I would list all of the things that your business has done to ready the workplace so it's safe for all employees. And you want to also establish a fixed firm recall date. And before you send those letters out, you're going to probably also want to manage the employees that you're not recalling, because all of these employees have been laid off, and before the pandemic broke out, and many employment plaintiff side lawyers will argue that a layoff is a constructive dismissal, and we can get into that as well, but it's exposing businesses to hundreds of thousands of dollars, if not millions of dollars in liability. So most employees have been understanding of the circumstances, and you haven't seen in many of these claims. You got the odd employee that wants to cash in on the pandemic, and they've wanted to exit for a while, and they're thinking this is their chance, and they're advancing these claims now. But you want to speak to the employees who are not being recalled to explain what's going on so they don't get frustrated and they don't advance constructive dismissal claims. Then also prepare yourself for employees who are not going to return, or who cannot return immediately for a whole host of reasons. And this is where, again, the devil is in the details. You're going to want to have conversations with those employees to figure out what exactly the issues are. In some cases, an employee has decided not to return, and it's a straightforward, I'm resigning, and there's no liability there, no liability or any compensation owing to the employee. And you can move along. But in some cases, the employee may, for example, have children at home. The schools are closed, daycare is closed, so they've got obligations to care for their children. That they have protections under the Human Rights Code. Other employees may have compromised immune systems. They can't return, or they have mental health issues that are preventing them from returning. So you want to work through those. For those employees, I would say now generally, and we can get into the specific details in terms of where the line is and how hard you can push as an employer, but I would say generally now is not the time to push. What you can do is you can accommodate them by allowing them to remain on an unpaid leave, which generally has no cost to the employer, and then recall someone else, or hire a temp, or hire another employee until they are ready to return to work. But of course, I can answer those questions if that's not an option for you. So then you have the recall, and then you're essentially recalling employees as per the recommended guidelines of the Ontario government, which the workplace may look different. There might be deviations, amendments to the hours of work. Employees may be coming in at different times, so there are not so many employees in the workplace. They may be coming in working 3 days remotely, 2 days in the office. So there's a wide variety of changes in the workplace that can apply to different industries, and I could go on for quite some time about those details. I don't think it'd be that constructive because it only applies to people in those specific industries.
When you talk about a committee, just to clarify on that, you mean a committee of a combination of management and employees?
Yeah, so there is no, okay, there is a legal obligation to have a joint health and safety committee that has management and employee representatives if you have 20 or more employees. But the committee I'm talking about is not that. It's a group that's going to help you get your business reopened. And so there are no legal obligations as in terms of who's going to be on the committee, but I think it's a good idea. I think you want to approach this cooperatively, and you want to get buy-in from your employees.
Okay, let's get to some of the questions that have been submitted by people on the webinar. Is an employer obligated to provide personal protective equipment like masks and that type of thing?
In some cases, even pre-pandemic times, the employers are, like for example, under the Occupational Health and Safety Act, some of the regulations, employers have employees, there are designated substances that if they're in the workplace, the employers have to provide masks, respirators. People working in the healthcare system, in some cases, the employer has to provide masks. So let's just set aside that group, and let's just talk about the general run-of-the-mill business. And my answer to that question is generally no. However, there are going to be times where you may have a rule or a policy in place. Another thing I guess I may want to talk about is policies and procedures that should be implemented when the workplace opens. But let's get back to the PPE issue. So you may want your employees to have PPE. For example, you may have a workplace where people are working alongside each other. You may have your frontline workers, your receptionists dealing with the public. You may want them to have masks. So it's almost like a uniform, right? You can say, employee, you're going to pay for your own work boots. We're not going to pay for them. You're going to buy your own suit and come to work. However, what happens if the employee shows up and doesn't have a mask? So I think it would be a good management practice to have masks on hand and provide them. But short answer to the question is you do not have a legal obligation generally to provide them.
Now, the flip side of that, which you started to talk about a little bit, is can you demand employees wear personal protective equipment, right? So if you feel that you want your team wearing masks, can you mandate it?
And yes, the answer is yes. In some cases, the guidelines, you may have to do it. In other cases, there's a general statutory requirement that employers have to take reasonable steps for the protection of their workers. So if you believe that it makes sense that this is reasonable to require masks, then you can roll out that policy requirement.
And what if there is somebody who is considered high risk or is worried about coming back to an environment where they might become infected? Can you force people to come back to work, or can they choose to stay at home if they want to?
Yeah, and now we're getting into workplace refusals, and I didn't mention that on my general overview of reopening a workplace, but this is a very important thing to consider, that the committee should consider. They should have a plan in place for these, because invariably there's going to be workplace refusals. Employees have a right to refuse work. So if an employee's in the workplace and determines that this particular task or duty is unsafe, the employee can stop working, report the situation to the employer, explain the task, explain the reasons for their decision that they're not going to perform the task. And then under the Occupational Health and Safety Act, the employer has to investigate the situation with a member of the health and safety representative, or a member of the Joint Health and Safety Committee, and come to a conclusion on whether or not the employee position is reasonable. And if they can't come to an agreement, then the employee can continue to refuse to work, and then either party, and if I'm on for the employer, I would say contact the Ministry of Labor, get them involved, and then a health and safety officer would visit the workplace and make a ruling on whether they're, I think you've asked me generally if they don't want to come to work because of fear, and I'm talking about a specific workplace refusal. And usually these rulings are made in a number of days, but you want to approach this collaboratively with the employee, because you're going to get more out of a relationship by approaching it that way. And also, a lot of times, a health and safety officer is going to come in and he or she's going to make a decision that is not going to be in the employer's favor. It's going to be in the employee's favor, and you want to prepare yourself for that so you're not embarrassed. Often you're seeing these health and safety officers coming in and saying, employer, you haven't done enough to investigate this at step one. Go back and investigate it. Look to these 4 or 5 things, and then get back to me if there's still an issue. So your question, sorry, Mark, was generally if someone fears.
Yeah, if somebody says, look, either I'm in a high risk category or I simply don't feel comfortable returning to work because I'm worried I'm going to be infected. I don't want to get coronavirus. Can I just stay home?
So I just explained in detail sort of the regulatory process for work refusals. If you're home and you just fear going back to work, or maybe you're comfortable at home and you're using health and safety as leverage, the answer is no. As an employer, you can say to an employee, no, you are abandoning your job if you don't show up for work on this date. Now, however, you got to dig into the reasons for the employee's position. For example, if the employee just recovered from cancer and has a compromised immune system, well, then that employee would be protected under the Human Rights Code. Say the employee has PTSD or something like that, and the fears are triggering symptoms. The employee would have a right to refuse to go in, and the accommodation you would provide the employee is to allow the employee to stay home. If they can do productive work from home, great, they'd be paid. If not, they would be unpaid. I recently watched, and actually you told me about it, the Netflix documentary Last Dance, and there's what I found really interesting about that whole documentary was the relationship between the coach Phil Jackson and probably the most troubled employee you could ever have in your life, being Dennis Rodman. And yet Dennis Rodman brought a lot to
this is a documentary about kind of the last season of basketball for Michael with the Chicago Bulls for Michael Jordan, right? A championship season after he came back to basketball in the 90s. Yep.
Right. And there's a lot of times Dennis Rodman made life difficult for the coach and was not following sort of where the direction that he wanted the team to go. But what was interesting was Phil Jackson often did not pick a fight with Dennis Rodman. So I guess when you're dealing with these issues, you want to think, first of all, do I want to pick a fight? Is this something I want to pick a fight with this employee on? I mean, sometimes it is. Sometimes you're going to go to the wall on this, and I would certainly be there for you if you retain me or one of the other KS lawyers. But a lot of times it makes more sense to back off. And if you've got a situation where someone has some legitimate fear, has indications that they are suffering from a disability, I would say don't force them back. Accommodate them, let them stay at home, unpaid if they're not providing services. It doesn't cost you anything.
What about childcare as a reason at this point? Because I think there's that dynamic too, right? Somebody maybe as an adult might be entirely healthy and not have a compromised immune system, but would say, look, I'm either a single parent or my spouse is not available to look after the kids, and there's nowhere for them to go. There's no camps open, schools are closed. So if you're asking me to come back to work, I can't do it.
Yeah, and you would have that protection as well. So under the Human Rights Code, there's a family status ground that is protected, and that would protect that employee, and they would fall into be treated the same as the employee with the disability that can't go back under these circumstances.
Okay, and somebody has asked this question too. There are employees who are starting to like working from home, right? I know it's not for everyone. There are some people who are anxious to go back, but there are people who are like, you know what? I just want to keep working from home from now on. What do you do with an employee in that case if that's not your preference?
So subject to the human rights considerations, this is still an employer-employee relationship. You're paying that employee. So you have, as a business owner, you have every right to roll out or insist on reasonable rules. And attending work could be one of those rules.
Okay. So a few related questions have come in already during our webinar. One person writes, we will be coming back in a staggered fashion. We're a physiotherapy clinic and don't know how many people we will need to have come back. How long do we have to bring them back if we still don't have work for them to do? This would be for both front desk and physiotherapy assistants.
So how long do we have to bring them back, or how long do we leave them on layoff if we don't have work? Like I would say, don't bring them back if you don't have work for them to do. I'll answer the question that I think is the question, and if I've got it wrong, you can correct me. So let's just back up, just talk about layoffs for a second, because that's a whole.
Yeah, that's an important area. Yeah.
Yeah. So before, the law as it is right now is that unless you have a employment contract or a collective agreement that gives you a business owner a right to lay off employees, a layoff is a constructive dismissal. So what did we all do and what was I recommending when the pandemic hit and you could not continue to carry certain salaries and employee expenses? We all said layoff. Some of those claims are coming forward. I'm actually kind of pleased. I haven't seen as many as I thought I would. I know the government, the federal government, there's some interest in legislating a solution for this that sort of kind of wipes out some of these claims, but probably I'm sure provides these employees with job protection, but that hasn't happened yet. Going to the starting point, the actual layoff was a constructive dismissal. Most employees are not treating it that way. That's great. Under the ESA, a layoff is deemed to be a termination after a certain amount of time. It's usually 13 weeks, but it can be expanded to 20 weeks if you're paying the employee benefits or some other conditions. So if you're bumping up against that deemed termination, which is going to be in June for many of us, then you may want to consider, that would be a factor that you're going to consider on who to recall. You want to avoid that deemed termination.
Yeah, so we did get another message from that person saying the current standard is 13 weeks. If we don't have work, can we extend that? So that seems to be what you're, yeah.
So you can extend it. You can extend it to 20 weeks, but the ESA requires that you provide the employee some sort of benefits. So typically what you see is providing them with benefits coverage during the layoff period, and then you can extend it to 20 weeks. And I should also say that people are lobbying the government to, I know BC recently extended that provision in their provincial legislation. So it is possible that the government, and you may see it in June, they may roll out an amendment to the ESA to extend that.
And so a couple of people have asked if with regard to this issue of people not returning to work because of concerns about their health or childcare considerations, that sort of thing, what's their status then? If you're asking them to come back to work and they can't, what is their status at that point?
They would be on a leave of absence most of the time without pay.
Right.
And that would be simply it. They could, there's a number of benefits that they could claim some benefits. Maybe that is beyond the scope of this webcast, but there are a number of benefits that the government has released to provide them with some income during that period. But yeah, they would be on a leave of absence. And I guess while it comes to mind, and I'm getting back to things you want to consider when we reopen, you may want to consider in your COVID-19 workplace policy is to make sure that employees are not motivated to hide their symptoms. So this particular with the working poor, I need this job. I need to provide for my family. I'm not feeling great today. I got to go in. So what you want to do is you want to give your employees an understanding that if this happens, there are these benefits that you can apply for, and we will help you make those applications. So you want to make sure that there's a safety net there, and you're encouraging them to report symptoms as opposed to coming into work and hoping for the best.
There's another issue that's come up a few times, which is, there's a whole political discussion that's happening around this as well, and that is about people who are going to say, look, I'm better off taking the CERB, as it's called, the CERB, rather than coming back to work. That's better for me. I get the same amount of money roughly, and I don't have to work, and I can stay home with my family. What do you do in those circumstances?
That would be simply a refusal. That would be, so they're abandoning their job, and you would recall them. If they didn't return, you'd confirm their resignation or their decision to abandon the job, issue them a record of employment. It's a resignation, and that would be the end of the relationship.
Okay. Here's a question that we had from before the webinar began. We are a fairly small company with limited amount of staff. One of our major concerns is what would happen if someone here tested positive for COVID-19. My understanding is that you have had contact with someone who has COVID-19. You must go into isolation for 2 weeks. Does this mean that all of our staff we need to isolate for 2 weeks and we would need to close down?
That one is interpreting the guidelines and recommendations of the public health authorities. So let me talk about the employment side of that. One of the things you want to cover with that committee that you strike is how you're going to monitor the workplace to sort of limit the impact of and avoid this. This is sort of your doomsday scenario that they're thinking of. You want to have employees that are monitoring the workplace for symptoms. It's not clear to me whether COVID-19 is actually going to be a disability under the Human Rights Code, but I would say presume that it is. And the Human Rights Code prevents you from actually asking someone if they're suffering from a certain disability. Like, you can't go up to an employee and say, are you suffering from schizophrenia? However, you can ask them about symptoms and limitations. So the whole COVID-19 thing is you want to educate a group of people to make sure that they're monitoring the workplace for any types of symptoms. And if you see someone who's exhibiting symptoms, you want to get them out of the workplace as soon as possible. And you could, I think it would be reasonable to insist that they return with a negative test. However, there's all kinds of false positives or false negatives these days. So you may also want to say, look, you're going to stay home. You're going to self-isolate for 14 days. And then you also want to cover off who's going to be reporting to the regulatory authorities under those situations, because there are regulatory reporting requirements under the Workplace Safety Insurance Act and the Occupational Health and Safety Act. And we can get into that as well. So short answer though is if there is someone who tests positive in your workplace, you're going to have to follow the recommendations of the public health authorities. And if they deem that this person was in the workplace and was transmitting COVID-19, that is a possibility. You may have to shut down the workplace, unfortunately.
Yeah, I know from a practical perspective, this isn't a legal answer, but from a practical perspective, I know there are workplaces that are dividing their workforce into teams who never cross paths with each other, doing things like that. Either they're working in different parts of the building at the same time, or they're never in the office at the same time. So that way, if there is someone who tests positive, it's only that group of people who is then forced to quarantine for a period of time, and you've still got the other group groups that can continue working.
And you remember, this is going to be a hit to the business, but what is the hit to your business if you end up on the front page of the Citizen as a business that knew that it had employees that had contracted COVID-19, did not take steps to isolate the outbreak, and got a bunch of clients or customers infected? That would be worse than the doomsday scenario that we're talking about. Another thing you want to also consider with your committee when you return to work are the regular cleaning and hygienic policies and procedures in the workplace. So you may want to have regular, like if you divide your team into those groups, you might want to have cleaners that come in between shifts, things like that. That would help also reduce the spread from team to team.
On this particular point of the health of employees and the risks associated with them being in the workplace, can you do temperature screening of employees, and can you mandate that? Can you ask an employee to get a test? Can you make that mandatory?
So temperature screenings, yes, there is, and first of all, this is all new to the Ministry of Labor and to judges. So I don't have a pile of cases. I don't have any cases to point to. As I say, in this pandemic, this was permissible, but temperature screenings, I would say, and I would recommend to clients that you can do that if you want to make sure that no one's coming in with a temperature. What you want to make sure, though, is in these temperature screenings is that you're not collecting private information from people. So if it's simply like one of those guns that you see where it's pointed at someone's forehead and it reads a number, and if that number is over a certain number, that employee is sent home, and the only thing recorded is employee sent home because temperature exceeded threshold or whatever, and that information itself is kept confidential, then I see nothing wrong with that. It's when you start storing and tracking temperature readings of different people, then that would be offside privacy legislation.
I want to come back to the issue of layoffs, and in a moment we'll get to some questions about reassigning employees and changing the nature of their work for a variety of reasons, because there are a couple of questions about that. But just walk us through again kind of the process of if you are eliminating staff, how you go about doing that under these circumstances. If there's been even a permanent change now in the scope of your business and you have to eliminate some positions. And one person asked, what amount of time is considered a permanent layoff during this pandemic?
Okay, so a layoff becomes a termination under the ESA after 13 weeks or 20 weeks if you're continuing benefits or some other payments to the employee. Technically, a layoff is deemed to be a constructive dismissal, which is a termination immediately, although most employees are not exercising that right. Sorry, Mark, just I got the last question.
Yeah.
The first question is how to
it's
go
more
about.
around, let's say you do want to reduce the number of staff you have going forward because of this, your business has changed, your revenues are down and are not likely to recover quickly. So how do you go about doing that? And what are some of the potential pitfalls there in terms of who you choose to keep and who you don't, and those kinds of things?
So similar to the recall analysis, you want to make sure that you're avoiding any possible violation of the Human Rights Code. So for example, if you have a poor performer and you want to put them on the layoff or dismissal list, you want to make sure that you understand the reasons for the poor performance, or you don't want to be the person seen to lay off employees that are about to go on a mat leave or something like that in 3 or 4 months. So assuming the layoff is based purely on operational requirements, such as I am going to eliminate all the marketing. Hi, Keith. I'm kidding. I'm going to eliminate this entire function. Then you don't have concerns about the human rights aspects of it. So then I would proceed with, even though it's a constructive dismissal, I would proceed with the layoff with the hope of you get the business back operating and you can recall some of those employees and you're not triggering. Most employees will allow it to happen. You're not triggering that immediate liability. However, eventually it will, if you don't recall them, it will be deemed to be a termination of employment. And then you got to look at your employment contracts. And liability could range from if you have a solid employment contract and your payroll is under 2.5 million a year annually, or a year, and see you've got an employee that's been serving you for 20 years, the liability there is only 8 weeks pay under the ESA. However, if you don't have employment contracts, those same circumstances, you could be looking at 2 years pay to that employee. So you also may want to consider the cost of the downsizing, and that may affect your selections.
But can you, if you say, look, we've got 10 employees right now, business is going to be down for the next couple of years, we don't know when it's ever going to come back, we need to get down to 6 employees, can you decide just to keep the best 6 employees?
Yep.
And okay.
Yep. And another thing you can do is to those 4 employees, you can give them working notice if you have time to get down. So at least you're getting some service from them. Most employers don't like doing that because it's awkward. You're working with the employee, and the employee knows he or she is their time there is ending, but that is another way to reduce your liability.
Okay. In terms of the responsibilities that people have, there have been a couple of questions about that. Can we change the job roles of employees due to new services we had to create in order to survive this difficult period? So can you reassign people, give them new jobs?
So the legal issue there is called a constructive dismissal, and that'll occur. A constructive dismissal means you haven't said you're fired, but you've constructively announced that intention that you no longer wish to be bound by your employment relationship. So the test is it's a unilateral change of a fundamental term of the employment contract. So unilateral, you can do anything you want with the agreement of the employee. So if you get the employee on side, you can make some of these changes. And sometimes you want to make very clear that it's a temporary change given these circumstances. So then you want to, if you can't get the employee on side and you do have to act unilaterally, you want to make the changes. It's all about degree. You want to make the changes that are close to what they were doing before. So if they were to take the position, look, I've been constructively dismissed, and they sue, a court may find, well, no, this was an adjustment to your duties. There have been adjustments in other times of your duties. It's not like taking a senior executive and turning them into a greeter at the start of at the front door of the building or something like that. Then lastly, you want to make sure that the relationship is respectful and the change is not humiliating to the employee, because sometimes even if a change is significant enough for it to be a constructive dismissal, the employee has an obligation to work through that period of time because it's not humiliating. So, compensation level stays the same, title and prestige within the organization stays the same. The duties are a little different, yes. The court would probably look at that situation and go, these circumstances, I think employee, you should have worked through that period. You shouldn't have just walked out and sued.
So if it's closer to being a lateral move and not a perceived demotion, that would mitigate against the risk.
Yeah, so in that case, you'd have a good chance at successfully arguing that it wasn't constructive dismissal. And also, if it was found to be constructive dismissal, you might have a chance for the court to find that the employee should have worked anyway because it wasn't humiliating.
What about logistical considerations, like, for example, an employee refusing to come into work if they have to take public transportation and they don't want to do that because of the risk of being around other people?
So that would again be, so long as it's not arises out of a human rights code protection, that would not be a lawful basis to refuse to work. You do occasionally see employees use health and safety as a form of leverage. I want to work from home for health and safety reasons, and the employer will say, well, look, we've taken these 15 steps to make this workplace safe for you, and the employee thinks, well, the only really safe thing is for me to work from home. and then you have an abandonment, or eventually the employer fires the employee, and then there's an accusation that there's a reprisal under the Occupational Health and Safety Act. So the employees, I guess I think I got off track there, but to answer your question, that is not a legitimate workplace refusal so long as it's not tied to a protected ground under the Human Rights Code. One of the things you may want to think about with that committee that you strike is what incentives can you create? You can't regulate the actions of your employees at home or when they're going to and coming from work, but you may want to entice them to, you may roll out benefits, like for example, our firm paid for parking for employees before the office was closed. So you want, with these benefits, you're going to entice the employee to make choices that are safer, and maybe you allow him and her to feel more comfortable coming to work.
Here's an interesting question. Is it okay for an employer to lay off an employee because that employee's live-in partner works in a long-term care facility as a personal support worker with a small COVID outbreak, but the partner has been tested and is negative?
Yeah, the answer is no. That would be a violation of the family status provision of the Human Rights Code. You can't just make assumptions about people or spouses or partners. So that would likely expose your business to an application to the Human Rights Tribunal.
Someone else writes, if we were to send someone home if they were symptomatic and needed to self-quarantine and they do not have any sick leave or vacation days left to use, are we obligated to pay that employee?
No. So the only time employers are obligated to pay employees who are not doing any work is when you have a contractual obligation to do so. So if you provide short-term disability benefits or sick leave benefits to employees, and the employee is entitled to those benefits due to the circumstances, well, then you have an obligation to pay. Otherwise, you don't. Your obligation is to protect the job, allow them to go home, rest up, and return to the job.
Okay. Someone else writes, we have on-the-road salespeople. What is our responsibility in sending them to customers? What liabilities are we opening up with the salesperson and the customer?
Yeah, good question there. I haven't even heard of many businesses doing outside sales right now. So you could get into a workplace refusal there if an employee is, for example, having to drive and stay in motels or hotels.
Or even going into someone else's place of business, right?
Right.
I don't think a lot of that's happening now, but I suppose in theory, it could over time as more businesses open up. Let's say you're a supplier to retail businesses and your employer might say, well, we want you to start going and visiting some of the retail businesses that are open and offering this product or service to them, right?
Yeah, so I would do my best to work around that issue. It's an interesting legal issue that we could all spend some hours trying to research and litigate, but I think you would be better off and it'd be more affordable to, first of all, talk to the clients. Do they want a salesperson attending, or do they want to do it virtually? And then talk to the employee to see what protections they want in place. So short answer is, to that end, off the top of my head, is I don't know, and it sounds to me like it could be you could be opening up a can of worms there.
All right. Here's another question. With medical situations such as recovering from cancer or another illness, I'd like to confirm we can ask for medical documentation to support their time to stay home and be protected under the Human Rights Code and be on indefinite medical leave. However, what if they don't want to return until there is a vaccine? Can the leave continue until that time?
Okay, so now we're getting into the line. My recommendation generally is to not pick these fights. However, if for a whole host of reasons, and you're the business owner, so you don't need any reason at all, if you want an employee back to the workplace, so those situations where the duty to accommodate, you have an obligation to accommodate the employee's needs, not preferences. So you often see in accommodation cases, the disabled employee will want, stars and the moon. And what your obligation as an employer is, when it's physical disabilities, you're going to get a report from the doctor. You're going to find out exactly what that employee's limitations are, and then you can build these combinations around what the employee needs, and of course your business needs. So in that case, with an employee with a compromised immune system, the line would be you'd need a report from the doctor, and you'd need some medical opinion that says the chances, the risks that present to this person if they were to catch COVID-19 are too significant. In my medical opinion, they should be staying from home, working from home. So that's what you need, some sort of medical advice that working from home is a need. And that's tricky because you're dealing with two factors. You're dealing with, well, how likely are they going to contract COVID-19 if they wander outside the home? And two, what kind of impact will it have on them if they contract COVID-19? So no clear answer to that one, but you could ask them for that medical information, and if you wanted, you can insist on accommodating only their needs.
I think we may have touched on this already, but it was part of another answer. So just for the sake of clarity, can you require somebody to get tested for the coronavirus before they come back to the workplace?
Yes, you can. If you believe it's a step that needs to be taken for the protection of your other workers, you can. Of course, you want to make sure you're careful about what you do with that information. It's personal health information from employees, and also, again, and I'm no doctor, I understand that there are situations of false negatives. Someone tests negative and 3 or 4 days later they're positive. So the easier thing to do might be to have them self-isolate for 14 days and then come back. But if you want to test, I don't think there's anything wrong with you insisting on a test.
Right. Although it's worth pointing out, even if the test is 100% accurate, which it's not, that's only saying the person hasn't contracted the infection yet, right? So they could go get the test, and in theory, on their way back from getting the test, could interact with somebody who has the virus and get the virus from them, and their test would still say they were negative because they got it after the test, right? So. Yeah, the test is only a snapshot of one moment.
Right.
Yeah. Okay, I think we have been through all the questions that have been raised. There's some overlap between some of the questions. So if we didn't directly answer your specific question, it's because it to me it looked like one of similar to one of the other questions that we posed. So JP, do you have any other general comments that you want to leave people with in terms of how they should navigate this tricky situation of returning to work?
No, we've been chatting for, I don't know, 45 minutes, 50 minutes, and we've kind of scratched the surface on many of these things. So you really do need a detailed plan. There are things that we haven't even covered in terms of our covered just in passing, in terms of your regulatory reporting requirements if there's if one of your employees does contract COVID-19. So it's going to take.
Want to expand on that?
Okay, so under one act, I think it's WSIB, it's a 3-day reporting obligation, and then Occupational Health and Safety Act, I think it's 4. But anyway, it's within days. And the issue is, I tell my clients, when in doubt, report. However, occasionally you'll have a business that doesn't want to report because they're concerned about the reputation of the business, or their concern is going to deter customers from attending their business. And what, from our discussions with the Ministry of Labor, is it's pretty hard to prove that the contraction or the virus is actually spread in the workplace. So if there's enough facts involved where you're pretty confident it was spread in the workplace, even if you don't want to report, I would recommend that you report. However, if you have no idea how this person got COVID-19, then you could take that risk. But my general recommendation is to report. But I guess the point being is that there's a lot of issues, and you want to take, you probably need assistance. So you need to strike your committee. You need to go through these things very carefully and reach out and get some help as you're going through these things in detail.
There is another question that I didn't ask, that there's just one that I missed, which is, what do you do about employees who you may have information that they've not been following social distancing rules outside the workplace? So, for example, you see on Facebook that they threw a big party at their house, or went to some event, or something like that. If you see that they're not practicing social distancing, what can you do about that?
So the first thing I would say is it's a slippery slope. You know, you want to be careful about weighing into what employees are doing on their own time, because then you're going to be. I would prefer to avoid that. However, there are times, like if this is, say, there's the example you gave there of an employee hosting a party. There are times where the employee's behavior is so risky that you don't have a choice. You need to protect your other workers. So if I were the lawyer, I guess, for the business that had that employee, I would first of all look at the evidence. How good is the evidence that this happened? And if you felt solid that this actually happened, and maybe you get a phone call with the employee and you get an admission, then I would insist that the employee would stay home for 2 weeks. It would be unpaid, unless the employee can work remotely. Again, the testing thing is I'm not 100% confident in the tests, but I think you would have that obligation for the protection of the workers. So let's just kind of, first of all, the courts are not open. So if the employee objected and sued for constructive dismissal, you're looking at a claim for 2 weeks pay. I don't think any employee are going to want to spend the money to litigate a claim for 2 weeks pay. So I think you're pretty safe to tell them to stay at home. And I think a court can be quite sympathetic, seeing the evidence of a house party and you saying, no, stay out of the workplace for 2 weeks under the circumstances. I think the courts can be sympathetic to you on that.
We talked a little bit about employees refusing to come into work and wanting to work from home. What about businesses that now decide they want their employees to work from home? Can an employee say, I don't want to work from home, I want to keep coming into the office? And what responsibilities does the employer have if they are now effectively asking employees, or even forcing them going further down the road, to work from home instead of coming to the office?
Again, it's the whether or not a human rights protection is involved. So if it's just a straightforward preference, then you can be a little more firm as the employer, saying, well, no, you are going to work from home. We are going to reduce our office size. You know, is that a constructive dismissal? I am not aware of any cases where that has been deemed to be constructive dismissal. And then, of course, the circumstances. This is not something that the employer is preferring to do. It's kind of forced into doing it. So I think you could take a pretty firm position with the employee and say, no, we're insisting on remote working. We want to close our office space, at least for the time being. However, if, for example, say the employee suffers from depression and the isolation is difficult, then I think you would want to accommodate that employee, allow him or her to come into work.
Okay. I think we've covered everything from the long list of questions that we've received. So JP, unless you have any other comments, I think we can wrap up there. Thank you.
Thank you, Mark. Stay safe, everyone.